Magna Carta continues to have a powerful iconic status in British society, being cited by politicians and lawyers in support of constitutional positions. Its perceived guarantee of trial by jury and other civil liberties, for example, led to Tony Benn's reference to the debate in 2008 over whether to increase the maximum time terrorism suspects could be held without charge from 28 to 42 days as the day Magna Carta was repealed, although rarely invoked in court in the modern era. In 2012, the Occupy London protesters attempted to use Magna Carta in resisting their eviction from St. Paul's Churchyard by the City of London. In his judgment, the Master of the Rolls gave this short shrift, noting somewhat dryly that although Clause 29 was considered by many the foundation of the rule of law in England, he did not consider it directly relevant to the case, and that the two other surviving clauses ironically concerned the rights of the Church and the City of London and could not help the defendants. Magna Carta carries little legal weight in modern Britain, as most of its clauses have been repealed and relevant rights ensured by other statutes. But the historian James Holt remarks that the survival of the 1215 Charter in national life is a reflection of the continuous development of English law and administration, and symbolic of the many struggles between authority and the law over the centuries. The historian W. L. Warren has observed that many who knew little and cared less about the content of the Charter have, in nearly all ages, invoked its name, and with good cause, for it meant more than it said. It also remains a topic of great interest to historians. Natalie Fried characterized the Charter as one of the holiest of cows in English medieval history, with the debates over its interpretation and meaning unlikely to end. In many ways still a sacred text. Magna Carta is generally considered part of the uncodified constitution of the United Kingdom. In a 2005 speech, the Lord Chief Justice of England and Wales, Lord Wolfe, described it as the first of a series of instruments that now are recognised as having a special constitutional status. Magna Carta was reprinted in New Zealand in 1881 as one of the imperial acts in force there. Clause 29 of the document remains in force as part of New Zealand law. The document also continues to be honoured in the United States as an antecedent of the United States Constitution and Bill of Rights. In 1976, the UK lent one of 4 surviving originals of the 1215 Magna Carta to the United States for their bicentennial celebrations and also donated an ornate display case for it. The original was returned after 1 year, but a replica and the case are still on display in the United States Capitol crypt in Washington, D.C.